Okay, good afternoon, ladies and gentlemen. The Metropolitan Board of Zoning Appeals is now in session for its regularly scheduled meeting of November 20th, 2014. I'm Joey Hargis, and I'll be presenting the cases for review in today's public hearing. At this time, I would ask everyone either to silence or put their cell phones on vibrate so as not to interrupt today's proceedings. The board would appreciate it. The procedure would be to introduce the case record as the Codes Department has it, and we'll do so on the wall here by means of a PowerPoint presentation. We'll present site plans, photographs, and maps of properties involved in today's cases. We'll also present any letters that we've received in support or opposition to a particular case, as well as correspondence from other Metro agencies. At the conclusion of my presentation, the applicants will come first to this table before you, along with any persons in support of their case. After the applicant has spoken, if there's opposition present, the board will then hear from those parties opposed to a case. And then after the opposition has presented their testimony, the applicant will have a period for rebuttal. The board in their rules provide that applicants in cases without opposition will have 10 minutes to present their case. And in cases with opposition, the board will provide 15 minutes per side for a case. And that's per side, not per speaker. So if you have multiple folks that wish to talk, please divide your time accordingly before you come forward. Where you'll be sitting here in front, just to your right is a clock on the countertop over there. We'll keep track of the time. That clock will run during testimony. It will stop for questions and the answers to those questions, and it will restart upon testimony again. All section numbers that I refer to today come directly from the Metropolitan Zoning Code, which was adopted by the Metro Council and became effective January 1st, 1998, and applies to the entire jurisdiction of Metro government. I'll introduce and make a part of the record a copy of the Zoning Code, which will be there at my desk, and I'll dispense from reading individual sections unless the applicant or opposition requests that I read those sections. The Zoning Code requires that these proceedings be taped. Therefore, it's imperative anyone wishing to address this board to come forward to the table, identify yourself, and then make your presentation. It should be noted that it's found that anyone's presented false or misleading testimony to this board that may have affected the board's decision. Approvals can be revoked at a later date by means of a show cause hearing. The board will go through all cases set for public hearing today, and after each case, the board will then discuss and then vote on your case in front of you. The board is vested with the power to act under Section 1740-180 of the Metro Code of Law. The code requires that 4 members of our 7-member board be present to constitute a quorum. The code also requires that you have 4 affirmative votes to grant your application. Today, I have 5 members present, so you need 4 of these 5 individuals' votes in your favor for your case to be granted. In the event you do not get 4 votes today, and there have been 5, and all 5 members hear the case, your case will be on our agenda for the next 30 days, however many meetings we have in 30 days, generally 1, sometimes 2. These 5 members are allowed to change their vote. The 2 members who are not present can watch the record on our YouTube page and review the paperwork and then become eligible to participate in that vote. If after 30 days no one's changed their vote and you're still tied up on your vote, your case is deemed denied by operation of law. In the event that only 4 members hear your case today, you still need all 4 votes to approve you, but in the event that you fail to get 4 votes, your case will be automatically reset for a new public hearing. We're currently setting cases for January the 15th agenda of next year. Any appellant or aggrieved property owner may request a rehearing within 60 days of today's public hearing. Further, any applicant or aggrieved property owner may appeal this board's decision to Chancery Court within 60 days. Within that same 60-day period, but after 60 days has elapsed, this board's decision is final and no further action can be taken. If you're an applicant and your case is granted, it is necessary for you to come and pick up the permit for which you've applied. I've had some applicants in the past come through this board and say, I got approved, I'm great, and start construction. Nope, come get your permit. You still have to follow up with the Codes Department to obtain your building permits or use permit, should it be that. Should be noted you've got 2 years from today's date to obtain your permit for this board's approval to remain valid, meaning if you do not act on that permit within 2 years, you'll have to come back here. But if you do obtain your permit within 2 years of today's hearing, your case, the board's action will stand with your permit. Mr. Chairman, I submit that all cases were filed in proper order. Appellants were notified by certified mail as required by the zoning code. All affected property owners within 300 feet were notified by first-class mail. An illegal ad was published in the Tennessean as required by the code. And before we call for elected officials, I do have a preliminary announcement. On our agenda, case 2014-107 on the middle of page 3, that case has been withdrawn by the appellants. That case was Leaps and Bounds Enrichment Preschool at 503 West Trinity Lane. They were requesting a special exception to construct a new daycare center. The case has been withdrawn by the applicant. So if you're here for case 107, that case will not be heard today. And that's all the preliminary announcements. The board allows elected officials to address this board before we begin. So if there are any elected officials who wish to address the board, please come forward. Councilman Matthews, I see you. Any other elected officials wish to address the board at this time? Okay, Council, it's all yours.
Appreciate the opportunity to speak to you this afternoon. I'm here to sit in the stead of Council Lady Karen Johnson, who is out of town at the National League of Cities Conference this week in regards to case 2014-106. I understand that Council Lady Johnson has written a letter to the board that you should have received, but she asked if I would come and just voice in person her support of this case and this variance being granted to the applicant. She has done her due diligence within the community. There is significant support within community, and she has been very transparent with working with the applicant and the community in this case, both posting the letter that she sent you all on her Twitter page, Facebook page, and sending it out in an email blast to her community to get feedback from the community. So there's overwhelming support of this variance, and ask that you give that consideration today as you hear this case. Thank you.
Councilman, which case was that for?
That was case 2014-106.
And when you say support of the zoning administrator, is that, I mean, her letter says that she's opposed to the appeal because it's an item A appeal saying that it was, the decision was wrong. I guess the bottom line is that you want the sign or not, but from what I get from her letter, it says we overwhelmingly oppose any appeal and variance in requested and required distance for this sign. We ask you please uphold the zoning administrator's original denial of this request.
She does not want the sign.
Okay.
She has a UDO and she wants to keep that in place.
Okay. Just want to make sure that. Awesome. Thank you so much.
No,
thank you for your diligence in coming for us. Thank you.
Thank you.
Thank you, Councilman. Okay. Ladies and gentlemen, the board does have a consent agenda, and a board member reviews the record in each case prior to the public hearing, and if in their opinion the applicant meets the criteria for the application requested and they feel that testimony in this case would not alter the material facts, they recommend a case to the remainder of the board for approval. I'll now call out those cases that have been recommended for approval, and if you're here in opposition to a case, please raise your hand, and the case will be removed from the consent agenda and heard in its regular order. The first cases were reviewed today by the chairman, Mr. Whitson, and the following cases have been recommended for consent. The first case recommended for the consent agenda is case 2014-103 at the top of page 2. Jacob Housewright, the appellant and owner of the property located at 118 Keyway Drive, requesting a variance in the RS20 district to construct a new one-story addition and carport to the side of the residence. Mr. Chairman, we had talked about this, and I just want to make sure the appellant's agreeable to the carport. Typically on those, we do those to remain open, not to enclose those. Is there any opposition present in case 103 on Keyway Drive? The appellant present. Applicant, any opposition to agreeing to not enclose that carport, to remain open? Okay. And with that, Mr. Whitson recommends that case to the remainder of the board for consent. The next case recommended for the consent agenda, bottom of page 2, case 2014-105, Mr. Michael Ray, the appellant and owner of the property at 5105 Pritchett Drive, requesting variance in the street setback to construct a new front porch. Any parties present in opposition to case 105? Okay. Seeing none, that case is recommended for the consent agenda. And finally, I know I'd spoken with an applicant, but I'll call it anyway. Case 2014-109, Mr. John Dawson, the appellant, 603 South 20th Street, requesting variance in street and rear setbacks in RS5 to construct a new single-family residence and garage. We do have opposition present, applicant present in the room. Once we start into our cases, if you two guys would mind talking, perhaps there's just have a chance. Mr. Dawson's there at the rear, and we'll let you two guys get together. Thank you. All right. So, Mr. Chairman, recapping the two cases currently on consent, case 103 and 105.
Okay, so we have a motion. Is there a second? Second. All in favor? Any opposed? Passes.
If you're here for cases 103 and 105, your cases have been approved on a vote of 5 and 0. Case 103 with the condition that the carport is to remain open. With that, you guys are free to go. Be sure to follow up with the codes department beginning on Monday morning to obtain your permits on both of those two cases. Okay, and we will call the first case now that will be heard. This case, I've got a couple things to go through, so let me get the first case is actually a deferred item from our November the 4th case, and it's on the first page of our agenda. It's case 2014-94. Ms. Lori Perry is the appellant. Nader Karshinas, the owner of the property at 2001 Lebanon Pike, requesting a special exception and variance in the lot size requirements in RS15 to allow to expand the daycare center to 50 children. Referred to the board under section 1716-170C2A. At the last hearing, the board deferred this case, essentially directing the applicant to go meet with the council member and the neighbors. In that case, we did close the public hearing. I had to check the tape again. So typically our testimony here is going to be based upon what happened after our appeal case. Unless you guys want to reopen the public hearing to hear more testimony. In this case, we only had 4 members that heard that case, of which there are only 3 of those members present currently. Those members that heard the case that are eligible, Mr. Harper, you are not eligible to participate. You didn't hear the first part of this case, so you're welcome to step out or hang out or whatever. I say, do we normally make them depart? I do, don't I? Not necessary.
If he's not going to participate in the case, then I don't think
Okay.
it matters.
There's not a recusal
Yeah.
involved in it. Okay, Mr. Harper, you're welcome to hang around. Those members that were present that heard the case, Mr. Taylor, Ms. Chappell, Mr. King, Mr. Ewing did hear the case, is not present today. That leaves me with 3. Mr. Whitson, to become eligible, you would have had to watch the tape proceedings on our YouTube page and review the record. Have you done so?
At the risk of revealing how big a nerd I am, yes, I did.
Okay. Do you wish to participate in this case?
I'll be glad to.
Okay. The record will reflect that Mr. Whitson is now a eligible participant in this case, so we now have our 4 members so we can actually hear this case. If I could please, Mr. Donaldson, if I get you guys to step out in the hall, I appreciate it. The acoustics are excellent in this room, so sound carries quite a bit. So we do have our 4 members present. So at this time, I'll call the appellant to the table. Ms. Perry, if you'll come forward. Members, as I talked about, I reviewed the record. We did close the public hearing. You asked the appellant to go back, defer, and talk to neighbors and council member. So generally, this testimony will be confined to that scope. 15. So the time, although to your right, really it's not coming into play. I mean, we'll leave it there running as a guide for you guys. But with that, I'll turn it over to the Mr. Chairman to Ms. Perry to address the board, covering the points from that point to now.
I guess I'll start by saying I'm Laurie Perry, owner of Donaldson Early Learning Academy. At our last meeting, I was asked to satisfy a neighbor who at that point, it was the only person in opposition, and basically to make him happy and do certain things that would make him comfortable with my variance being approved. And so I do have a letter, and each of you should have gotten a copy. I don't know if you've read it yet or not. Like he said, I went over, even extended what I was asked to do to make him happy and satisfied. And the letter says that he is no longer in opposition, and he offers his full support in my endeavor to increase child care capacity to 50 in my daycare.
Yeah, you were also asked to kind of meet with your council person and talk about any potential compromise or other plans. Did you all have any other meetings and any other community discussions besides the neighbor?
It was said, and I think, if I'm not mistaken, I don't remember who said it. Someone said right at the end, no more mail-outs, no more signs needed to be done between then and now.
Yeah, that wasn't my question. My question was, did you meet with the council person to talk about the differences that were expressed to see if there was... No, I have not had a meeting with him. He was present. He had the opportunity to hear that the board simply asked me to do one thing, and that was to make my neighbor happy and change his mind and fulfill whatever he was asking me to do to no longer be in opposition, in which this letter says that I did, in fact, do that. Okay. Not to get argumentative, I remembered it differently. I remembered that being one component, and I do remember one of my fellow council or commissioners saying, well, you definitely have to please the neighbor, but it would behoove you to talk with your council person in the opposition to see what you all can live with. So
he's followed this entire case from the beginning.
That's fair enough. I mean, that was okay. I guess the only other question is, when I thought about this after we heard it before and now, and was there's not enough space according to code on your land, and that's the issue. You have, I think, 80% of, or 6/10 of an acre, and you're required an acre. And there was opposition specifically because of that. And you had said that it took 30-something kids to make it profitable, and was wondering if there was again some other alternative besides denying the request or fully approving it, which there has been neighborhood opposition expressed about. So the question is, from your perspective, what can you live with?
It would take 35 just to break even. That's what I had even had a conversation with Joey Hargis about that in his office, that he's very familiar with it. That would be just to pay the overhead affiliated with running the preschool.
Okay.
So if I lose this, if I don't get the 50, I lose absolutely everything. My children lost their father at the age of 5, actually 2. He was chronic vegetative and died when they were 2. And I have worked very hard my entire life to support them, all 3 of them, on my own. And I have finally got this opportunity to not have to pay $6,000 per month for rent. I've worked so hard, and for 16 years I've been a licensed director with the state of Tennessee, and I finally made it here. And I just don't get Claiborne's opposition to me. It's almost like, I don't know, I don't get it. I've worked so hard. I've put everything, I've invested everything, every dime that I could scratch up, everything. I've worked myself there scraping drywall at night because my contractors wouldn't show up for 2 weeks because they had other jobs going on here and there. It took me an entire year of construction to get it to where it is now, to go ahead and comply with 50, because I was promised by Phil Claiborne, and I had documented as we spoke, that all I had to do was go to the BZA, get approved for 24, and then I had to go to him, pay $1,400, and that he would back me in getting me rezoned. When his friend that opened her second location within a mile of each other, that's when he walked in and he said, walk out. This man actually walked in 7 or 8 o'clock at night when I was there working, covered in drywall dust, asked me to walk out and quit right now and take my losses. And I said, Mr. Claiborne, you don't understand. I can't do that. I've put my life in this building. I've put everything I have in it. I do understand that. I knew in the beginning that it had just over a half-acre lot. But if he were to follow through with what he had promised to do and rezone me commercial, then it no longer would have mattered. I would no longer have been required to have that full acre. He misled me from the beginning. I didn't even purchase this property or sign a contract on it until after I had spoken with him and after I had spoken with multiple people at Codes to make sure that I could get this through. Otherwise, I would not have spent the money and the time. This is my life. If I lose this, I lose everything immediately. And the opposition here is my competition, trying, it seems to me, dominate the entire area. She has 2 within a mile of each other. They seem to be very profitable. I think she's probably at capacity at both of them. It's just greed. She wants to have 2 and dominate the entire area and then completely destroy my life and take my one that I've worked so hard for away. And I really need these 50, and I have more than enough square footage to accommodate 50. I have more than enough parking spaces to accommodate 50. When I was here last time, I brought many pictures that showed areas of my property that I do not use, will never need, that just have to be maintained and cut, because I will never need them for 50 children. I just don't need that much space.
Okay. And I remember you telling us that last time, so I thank you.
As I remember the case, you were asked that you had opposition to meet with the people that were in opposition. And I don't recall one person that you were limited to get their support. So you're saying you only talked to the one person that you got the letter from? You did not talk to the other opposition?
What I was told, the final words leaving that hearing, I was asked if I had spoken with the person that was here in opposition, which was the neighbor who hasn't even moved in yet. He's still in the remodeling stage. And to work it out with him and then come back today and I would be the first one called. That's what I did, and it took quite a bit of money to satisfy this man. And I have a copy of the check that I had to write him on the impression that I was given the impression that that's what I needed to do to satisfy the board, to satisfy him, and finally everyone be happy and in support of my preschool. And I have a letter that was dropped off. I have a copy of it by a neighbor, the lady that lives next door to this other preschool that's here in opposition of me. She is very, very displeased, and her name is here. I don't know if she's fallen ill. I have not been able to get her at home. She has not been home at home, but I do have a phone number here if anyone wanted to call her. She feels very strongly. She's retired at this point, at her age, She has followed this from the beginning, and she's very displeased with the preschool that she's next door to, which is her other one.
Hey, ma'am, I don't think we're trying to open up the public hearing again. I think.
Yeah, we don't want to do that, but not everyone is in opposition. Some people really want me and welcome me there.
No, I get that.
And this is a letter.
But I think Mr. King asked you a distinct question about speaking to others besides the one neighbor.
Other than, it's the only opposition that I knew other than Claiborne and then my competition. And she did not fall within my 300 feet. She was not on my mailing list or anything. She was here, but I have not spoken with them since. I was not told to. I was told to meet with this one person, satisfy him, and then come back today, showing that I had satisfied him. And that's what I did.
I don't recall that stipulation. I recall, sometime I forget what I had for breakfast, but I believe I remember you were asked to get support of your neighbors because that was very important to your case. That's what I remember. And maybe I'm wrong, but that's what I remember. I didn't make the motion, but I remember that portion, so.
No, he was sitting back here and he said, I haven't. He said, but I would be more than happy to speak with Miss Perry and so we can work these details out. And he left me a letter of what he wanted me to do to satisfy him. And I, like his letter said, even went above and beyond. I've tried to do everything that has been asked of me to do to comply and make everyone happy. I have offered to I have a neighbor on the other side. I had a neighborhood meeting. If there were questions, if there were opposition, they had an opportunity to show up at that meeting. Voice those to me then. They didn't show up. The only person that showed up was Councilman Claiborne. No neighbors showed up in opposition. I don't see any other opportunity given to me or anyone else asking me to do anything to satisfy them. If they would have been present and asked me to do something to satisfy them. If Claiborne had asked me at that meeting, at that last hearing, to do something that he wanted me to do to satisfy him, then I would have been more than happy to do that. Any opposition, anything asked of me, if it were at all possible within my means of being capable of doing, I would have done that. This is the only thing that I was asked to do, was to satisfy this neighbor. And I did that. There was no other opposition here at the last hearing other than Councilman Claiborne and the owner of the preschool down the street, which is my competition. That was the only opposition that was here. No, there was no other opposition. And her being my competition didn't ask for anything that day for me to do to make her happy. She's several properties down from me. She didn't ask anything of me, nor did Claiborne. Only one person did. And his name is Mr. It's very hard to pronounce. This is his letter. And I satisfied him just as I was asked to do. Other than that, there was nothing more asked of me to comply with.
Okay, thank you. I think we're apprised of your position, and so thank you very much.
No other question.
I mean, with the board's permission, I would think it would be only fair to ask Councilman Claiborne if he wants to say something. I mean, I wasn't a part of the first hearing, but I think that in fairness. So, ma'am, we'll ask you to step down from the table, and Councilman Claiborne, if you'd like to speak, you can certainly. I don't think we're opening the public hearing. I think we're, as a point of personal privilege, one, to an elected official, and two, to someone who ought to be given a chance to respond.
Thank you.
members of the board, Chairman. I'm Phil Claiborne. I live at 2911 Western Hills Drive. I represent District 15, which is the Donaldson, Two Rivers, Pennington Bend area. And I do appreciate the opportunity to respond to a couple of comments that were made directly to me having to do with previous conversations. As Ms. Perry stated earlier, that when we first talked, I made her aware of the fact that she didn't have the proper acreage to go to 25 people, 50 people. She had told me that she was going to start with 25 and move to 50. And I told her that she didn't have the space to do that, nor did she have access to a collector street. So in the last time that we were here, the collector street issue was questioned. So with your permission, I'd like to read definitions of a collector street. A collector street or road or distribution road is a low to moderate capacity road that serves to move traffic from local streets to arterial roads. Unlike arterials, collector roads are designed to provide access to residential properties. An arterial road or an arterial thoroughfare is a high-capacity urban road. The primary function of an arterial road is to deliver traffic from collector roads to freeways or expressways and between urban centers at the highest level of service possible. Lebanon Road is the only road that this property has access to. The traffic count, the last official traffic count that I had on Lebanon Road, put it at the 4th busiest road in Metro Nashville. 31,000 plus cars a day traveling on Lebanon Road. Lebanon Road is an arterial road. It is not a collector street. And the rules for level 2 daycare specifically state an acre in size and access to a collector street. And as Ms. Perry stated earlier, I did tell her that she should cut her losses and move on. When we talked about the fact that she couldn't meet the requirements to move to a level 2. So, you know, I did tell her that I would not zone this commercial also. And I don't know where she gets the indication that I did promise to do that. The daycare that she references that is within 300 feet of where she currently exists was already in operation several months before she even bought this property. So it's not a fact that I changed my mind when this new daycare opened. That is a misstatement or an untruth. This existing daycare was already in operation when Ms. Perry purchased this property. The lady who has the existing daycare can operate, I think, with 40-something kids. It is a grandfathered location. Ms. Perry has the right to go up to 25. Adding another 25 children puts the possibility for close to 100 children playing outside at any given time in the summertime. And I do not think that, I think that has a negative effect on the tranquility of this quiet neighborhood to allow that kind of concentration of children. And I also think that it has a negative effect on the property values. In fact, the Planning Commission, in their recommendation on this, said the intensity of the proposed use, location, and size of the parking area and lack of landscape buffers is inconsistent with the surrounding residential uses and land use policy, and would have an adverse negative effect on the surrounding residential properties as the lot size is insufficient to accommodate increased activity and traffic. Ms. Perry said that she had only a mandate to only satisfy one person. You had a letter when we were here last from the neighbor on the other side in opposition. And these individuals are here today expressing their opposition by their presence, even though they can't be heard. You told Ms. Perry to go back and talk to all of her neighbors and to the council member and see if we could work out some common ground here. I have not had any contact from Ms. Perry, and as far as I'm able to determine, none of the other neighbors, with the exception of the one that she mentioned buying storm windows for and adding additional privacy fence, is the only one that she's talked to. So she has not met your mandate based on the reason that we had this deferral. I'm not against Ms. Perry. I'm not against small business. I am standing here because we have a clear statement of what is necessary to move to the next level for this daycare center. And I have made those requirements made known to Ms. Perry from the very beginning of our conversations back in late March or early April of last year. So if you have any other questions, I'll be glad to address those, but that's...
Yeah, well, the question that I asked Ms. Perry was, if we were to look at this and to try to figure out is there a middle ground that is acceptable, in your opinion, is there a number that, whether it's 35 children or 38 children or 32 children, that's more than 25 and less than 50, that kind of given the entirety of the situation would make sense and seem fair or not?
No.
That's it.
Any other questions? Okay, then I'm going to move to close today's hearing as well as the public hearing. Discussion?
Mr. Whitson, tell me about the special exception, what we need to find that will help me to deliberate.
Actually, instead of me doing that, I may let our legal counsel do that. Would you like to, or do you want me to tackle it?
For the special exception uses, it's really almost ministerial. They either meet those requirements for that special exception and thereby it can be granted, or they don't meet those. Here you have a daycare, so you would have to look at the specific requirements for daycare, and I'll have to yield to Joey on those specific requirements for the special exception. But she's also asked for a variance in her lot size, and for that she would have to meet the requirements for the variance dealing with the hardship, the topographical nature, the things associated with the land that explain why she cannot comply with the zoning regulations. So that would be what you're looking for on that side. So you really kind of have two things. One is more ministerial. The other is requires the prongs of a variance that she has to be able to meet. And you have to determine whether or not she's met those. And if she has, then you can grant the variance. If she has not met those, then you cannot grant the variance. If you give me a second, I can pull those up for you as well if you like.
But I will note that one of the requirements is maintaining the integrity of the adjacent areas, and I do think the Planning Commission's report spoke to that. Well, in absence of that, and actually I don't want to do that. I mean, because y'all listened to the whole thing. I mean, I did too on the TV, but I mean, just my thoughts from having watched the original hearing and today is that I have seen evidence to the fact that it would have a negative impact on the surrounding area, that being our Planning Commission as part of its finding. And then really I've seen no evidence as to the hardship that would allow a variance. I've heard a lot about personal hardship and economic hardship. I have not heard anything about the state of the land, but that's just...
And the minimum lot size is what?
Is one. I was just getting ready to. Is 1 acre. So under the institutional special exceptions, she is required to have a lot size of 1 acre, and the street standard is at a minimum driveway shall have access to a collector street. So those are the two standards that, one of the standards of which she's seeking a variance from, and that's the acreage So for that, you would have to come back over to your review standards in 1740-370, dealing with the physical characteristics of the property, unique characteristics, hardship not self-imposed, financial gain not the only basis, no injury to the neighboring properties, no harm to the public welfare, and integrity of the master development plan. But our code requires that those prongs be met.
And the variance on the property would require a hardship, correct?
That's correct.
Okay. And I heard no hardship. I'll decide anyway, I'm sorry.
Yeah, the hard part about this one, these are the kind of cases that we like to, especially when they're deferred, come back with a solution that is amenable to all parties, especially given everything that we've heard. And I remember that being part of what we'd asked to say, let's go see if you can make something work with everybody involved, including the council person. And I don't know that that's possible, given the positions that everybody's expressed, but I don't think that necessarily happened. But I guess the fundamental legal questions that we're looking at are, the hardship piece of the variance, which for those characteristics that we've talked about in terms of hardship really weren't there, that we're able to look at. I mean, we can't look at the person. I mean, it's we're very empathetic to the personal hardship, but it's not something that we are able to disregard the legal requirements to support. And I guess I guess that's all I have to say on that. I did have a question of, for the applicant, because I do know it's not to ask the applicant, but as an answer, if we aren't able to grant this variance today, you can bring these, you can try to work things out, come back later, and what is it, a year? How long?
6 months under the rules.
So if things were to change in 6 months, then you could come back and make another case, but you would have to answer those specific questions on the variance and hopefully have a more cohesive neighborhood plan that would meet the Planning Commission and the council person and the other folks involved's concerns.
I have to agree. I mean, I think we don't have anything, I have not seen anything at this point that causes a hardship to waive the 1 acre requirement. But I would also say that is the main thing that sways my argument. I appreciate the opposition that was here last time. However, I don't think the other business owner can provide necessarily objective opposition. I do think Ms. Perry has done everything and more that one neighbor asked to do. She did hold a neighborhood meeting that her other neighbors, who apparently are here today, did not attend for whatever reason. So I think she satisfied anything we would have asked her to do, the law asked her to do with regard to those neighbors. But I don't see that she meets the requirements for a variance.
I'll agree with that.
Is there a motion? Oh, okay, I'll make the motion. Based on the recommendation of the Planning Commission with respect to the special exception and the failure to have evidence in the record as to a physical hardship related to the land that would justify a variance of less than 1 acre, move to deny the applicants. Is there a second?
I'll second it.
Okay, got a motion, got a second. All in favor? Passes.
Case 94 is denied on a vote of 4-0. Mr. Chairman, a couple housekeeping measures. If you'll recall, first we had a case on the consent agenda that we withdrew from the consent agenda. The applicant and opposition had a chance to talk, and they have worked out any difference is she actually came by to see me and say that she was now in favor and talked to them. So with that, we'd like to put 109 back on consent, and I've got a motion and second as Mr. King seconded.
Okay. Got a motion, got a second, all in favor? Any opposed? Passes.
Okay. Case 109 approved on a vote of 5-0. And Mr. Chairman, we do have a deferral request, and I'm sorry I missed this at the beginning. On case 104, the Z-Mart, the appellant, opposition and applicant met before today's hearing, just before we got started, and I believe both have agreed. I know that the opposition has departed, but the applicant for Z-Mart on case 104, you agreed to a deferral to December 4th. That'll be our next meeting. Okay, members. Members, any thought to placement of where on the agenda? Do you have a preference? If not, I can do it in the usual location. Okay.
First, I mean, anybody have a problem with putting them first? First would be great, Joey.
Okay. All right, I do need a motion and a second on that deferral.
Got a motion for them to defer, well, a motion on the deferral and to put them first on the agenda. Is there a second? Second. Motion second, all in favor? Any opposed? Passes.
Okay. Case 104 is deferred to the meeting of December 4th. That's our next meeting. It'll be first on the agenda to give those parties time to talk to each other. Okay, Mr. Chairman, let's see. The next case before us is case 2014-106. Johnson Sign Company applicants present. Any opposition present to case 106 on I've got Old Murfreesboro. It's actually Murfreesboro Pike as well. That parcel is a double frontage lot and has two street addresses, both of which are 1907 on Murfreesboro Pike. But before we begin, there are two portions of this case. Before we get into that, I do need to turn over, I guess, to our legal counsel. Is there anything addressed? Okay. So the first portion of the case will be the item A appeal. Members, this will be actually two parts, and we do need to deal with them independently of each other. Because success by the appellant on the item A will actually, the variance portion will go away. So first, in an item A appeal, the zoning administrator will go first. So, sir, you'll go second in this one, but you'll also have a rebuttal period. Any other parties present who wish to address the board on case 106, there's an opportunity for a third party to have input, and I see none. So we'll only have two parties in this case. So in this case, the zoning administrator will go first on the interpretation question.
Okay, this is a two-part appeal. My understanding is that we have an existing sign that may have actually two signs located on one pole, as I understand it. One of those two signs, both of those signs are static signs. One of them is the applicant wants to convert to a digital sign. This office denied the request based upon Metropolitan Code Section 1732.050G and the following parts, which says, in short, that this is a CS-based zone district, and so digital signs are allowed in CS based upon the satisfaction of certain conditions. And one of those conditions is a distance requirement. And so what it says is that you have to be within, you cannot be within a certain distance of either agriculturally zoned or residentially zoned property. It's my understanding that this sign does not meet that distance requirement. So based upon that prohibition, our office denied the request. Now, so you would think that that would be a request for a variance from the strict application of the requirements of the zoning code, but there's also an item A appeal here. In looking at the application, saw no factual basis for the item A appeal. In other words, if you look at the application and the document that was submitted by the applicant, there was no assertion in there as to what the zoning administrator did incorrectly. So I can only presuppose that the item A is that we should not have denied the request based upon the distance requirement. Beyond that, I don't see any factual or legal assertion as to what the how the zoning administrator erred. So, in my mind, really, this becomes a straight up variance case.
Okay, let me interrupt for just a second and ask our counsel about that. And maybe Joey can answer this. How can an appeal end up on our docket if there's no reason for the appeal given? I mean, I know anyone can file the appeal, but how is it decided that it's an appealable issue, or for that matter, what that issue is?
Well, I think I can answer that, and that is because they do have an appeal as to the variance part of it. So there's an appeal there. Our office does not support that appeal because it's contrary to the distance requirements under the zoning code. However, any decision that my office makes or that I make is appealable as a matter of right to this board. So my decision was to deny this request, and so they've appealed that decision.
So we need to ask the applicant what the item A part is.
Well, I think my question is perhaps out of my own ignorance, but I think it's more of a structural question. Yes, any issue can be appealed, but don't they have to say what the issue is?
Well, if I can help.
Or can they just say, I appeal?
I will schedule a case to this board based on what Mr. Herbert's talking about. I have to send them here. I will not read their letter and edit it for content that, I'm not in any way going to make an argument for or against their writing. Their writing was what they've submitted to you. But I'm not going to editorialize it or say, hey, I don't agree with that. I'll take it as they've submitted it.
Okay.
And it either rises or falls upon their testimony and or the letter they've submitted, if that makes sense.
Okay. If the lawyers up here are happy with that. And like I said, it might just be my own personal ignorance.
I have expressed, and let me say this, not on this particular case, but I've expressed frustrations with item A appeals of constant appeals of the same thing over and over. Different locations in town, but it's the same point of thing. But I'm directed by the legal department. I must take all appeals as submitted to this board.
And
I'm sorry. So is this the appeal?
Yes, that's the item A portion, is the handwritten letter. And two, also, keep in mind, we have not heard from the applicant. The applicant clearly has got an opportunity before you to argue their part of the item A before we get into the distance part. But the reason I set this up initially as I did, we have to deal with it in two pieces and deal with them separately. Because a success on one would eliminate the other.
In short, if an applicant comes in and says, I want to appeal based on a variance and an item A, that's exactly the appeal that we take.
Okay. All right. Didn't want to muddy that up. I just want to make sure I was clear on that.
And just to add to that, that's one of the decisions that the board, it's probably a threshold decision, is whether something has been alleged that you can grant some sort of relief for under the code. So the staff is not making that decision. They're accepting the application. But the board can say either something has been alleged or something has not been alleged that is appropriate under the code. And what if something has been alleged, what remedy this board would offer, or if something has not been alleged, what the motion of the board would be, or the pleasure of the board would be.
Okay. Thank you.
So, Joey, are you going to present? Oh, I guess. Or does it go to the applicant now?
Yeah, generally in these, sorry, I was checking our monitors at the back. In these types of appeals, the zoning administrator go first, and any and all questions you have for him, because he only gets one period to speak, and the applicant will go second as far as stating their case. And then normally third parties, and then the applicant will get a rebuttal period, but the applicant is the only other party present for this case.
So any other questions for the zoning administrator? Okay, let's hear from the applicant.
I was enjoying the communication back and forth, and a very good point made. My understanding, correct me if I'm wrong, you're a lawyer, I'm not, is that to come before this board, you have to have some kind of hardship. And in this case, we don't have a hardship. We really don't. What we have is a situation where the applicant for the sign permit has in place, by permit from the city of Nashville, a static reader board. All he wants to do is change it. He wants to come in to the new age and change it from static to electronic. Now, can he get a permit? Absolutely. He can get a permit, not at that height, but we can get a permit to put an electronic message center up there at whatever that sliding scale height is, correct? So it's not a question of whether we can get a permit. But this board has before, like with RCS Motors, they were up against a zone residential property. Now, granted, it was a cemetery. But when you look them up, it don't say what they are. It just says this is how they're zoned. And this board approved letting them put one up. Good Feet, out on Gallatin Road, I believe it is, they got a permit just by submitting because they happen to be at the right height. So my customer is not asking this board to do anything other than let him change out a static reader board to an electronic. I think Tom White was here once before, and he argued a sign is a sign is a sign, and all he's wanting to do is to change it out. We've had these discussions before about signs in districts, and they want to change out the face to read from my store to your store and get into situations where the sign was grandfathered in, this tenant moved out, another tenant moved in, and then all of a sudden they want to make them apply by another set of rules, and that has since pretty much gone away. So my tenant, my customer, my client is asking that he simply be allowed to change out an existing static board, static reader board with one that's electronic to go no higher, no lower, and no larger than what's already there.
Yeah, you said that you could get a permit to do this. What would be the height of the sign to do that without a variance or without us overturning the zoning administrators?
I'm kind of like Richard. I can't remember what I had for breakfast, but it's somewhere 9 feet, 10 feet, something like that, I think.
And I mean, I see the picture of the sign, and I don't see a hill or any physical characteristics of the land that would require it to be higher. I think that the tire company that you spoke about did have physical characteristics of the land that was the reason that I think that variance was given.
Well, if I remember RCS Motors, and I was involved in that to some degree, it was about the zoning regulation.
Is that the one across from the cemetery? Mm-hmm. Do you have any testimony over what residential land is within the?
Well, if I could,
custom auto.
What is the residentially zoned land that's keeping us from?
It's behind.
But it's not a cemetery. People actually live there.
Yeah, it's behind. Okay. Now, here again, this customer, he only wants this sign on one side. He wants it on the side facing Laverne, not the side facing Nashville.
guys, can I stop y'all's discussion for a moment? Because you guys are both talking about the variance portion of this case. So I've got to get y'all back on track that the first part that we're talking about has got to be this item A. And I'm going to read, let me read into the record. This is what the appellant sent me as their item A letter. And it says, please accept this application requesting a BZA hearing regarding the digital display for Custom Auto. They currently have a manually changeable board and would like to update styles to an automated board. The new board will be the same size, same height from grade. We contend, this is Jocelyn Sign's representative, we contend that a sign is a sign is a sign, and a reader board should be allowed no matter what style or in what manner the letters are changed. That's what's before you now. And our position, as stated by the zoning administrator, is that no, when it comes to LED, they are not the same. And courts have told us they are not the same.
And that's based on exactly what?
That's his item A.
It's what we just heard from the zoning administrator saying that that the code specifically says digital billboards are allowed, but only under certain conditions,
Right.
and these conditions aren't met. So it specifically addresses LED. Okay, so we need to decide the item A part. Do you have anything else to add? I guess is that your item A case? That's the part where you say the zoning administrator was incorrect in his interpretation?
Correct. And added to that, we have, and the city approves them now, and we had this case come up out on Gallatin Road where electronic gas pricers used by convenience stores, which are segmented, and time and temp units are exempt from this. We had a parcel of property for a MAPCO, and they wanted to put in electronic gas pricers, and they said, well, there's zone residential property right next door. We looked it up, and that zone residential property was a strip of property 5 feet wide that ran out into the center of Gallatin Road. And for some reason, it just showed up on the map. Since that time, electronic gas pricers have gotten permitted, and they're electronic, they're digital.
I'm going to do a public service here because I don't blame the public for being confused by all of this. There has been a lot of turmoil over these LED signs for a while. We've had a lot of cases. Unfortunately, it took the Court of Appeals a long time to rule, but they have ruled. And so this argument that a sign is a sign is a sign, which we have heard before and which we have agreed before, a Court of Appeals has now told us is wrong. And so we as a board are now legally mandated to not accept that argument. And so we've got to put that to the side, and I have no doubts you can spot LED signs all around town and how it's passed, but I really think you need to speak to why the zoning administrator was wrong. I mean, because that's what this is. This is an item A appeal. Why was the zoning administrator wrong?
I think he was wrong in the fact that the customer has a reader board up there now. He wants to change the face out in that reader board from one style of reader board to another style.
Okay, but the reason the zoning administrator made the decision he did
Was because it was electronic.
correct, and there are restrictions on that, namely how close you can be to residential property, and this is too close to residential property. I mean, that's his finding.
Based on their interpretation.
Right, and you have an opportunity to give us a different interpretation for us to decide, well, was the zoning administrator wrong? Now, if we say, no, we agree with the zoning administrator on that part, then we will talk about the variance to say, well, should there be a variance in this case to allow this?
Well, we looked it up on the GPS, and we have a sliding scale, and we saw that based on the sliding scale that it didn't meet the height requirement. We are saying that height requirement or not, this is a customer that has a sign, that has a permit, and he wants to change out what's on that face of that sign, whether it be an electronic message board, a blank board. What if he wanted to put up a Trivision board? The same things are holding true here.
But excuse me, with respect, I think since the appeals court has weighed in on this, that argument is not with us, it's with that court.
Is that the Court of Appeals on billboards or on all electronic signs?
Well, whichever court handed down this decision, see, we are now required, it's not something that we can grant a variance on or allow an exception on, because now we have been told by a higher power, literally, that you must interpret this way, just as the administrator must interpret that way. So your lawyer, perhaps our lawyer, could direct you to whom to take that argument, because we can't rule on that, on your argument about it. I think I'm correct in that. I see my counsel nodding their head.
I would like,
The basic question before the board is, has the burden here been met in terms of alleging something that shows that the zoning administrator was in error? That's your question for the item A. In applying 1732-050, which says that the following signs are expressly prohibited, and then it goes on to say signs with any copy, graphic, or digital displays that change messages by electronic or mechanical means, or digital displays. And then it says section G, and then subsection C talks about CS, and it says signs 4 feet or less in height shall not be less than 100 feet from the property of any agricultural or residentially zoned property. Then, it goes on to say, each additional foot in height or proportion thereof above 4 feet shall be set back an additional 25 feet from any agricultural or residential zone property. That's what the code says. So you have to determine whether or not any errors were made in enforcing that code.
so I guess if there's no other testimony, I'd like to close the public hearing on the item A part of this appeal, so I'll move that.
I'll second.
Discussion?
I don't see, I haven't heard anything that would give evidence that the item A appeal has merit, and I think the zoning administrator was correct. So I would move that we deny the item A appeal and affirm the zoning administrator's interpretation.
I see a nod, so that's a second from Cindy, and so all in favor?
Aye.
Aye. Passes.
Part 2 of the case, the variance portion. Let me back up just a little
Yeah,
bit.
you're still here. So
Still here, you got. Now we're gonna
we're
talk
saying he
about
was
the
right,
distance.
but you're asking now for a variance. So
Okay. Let me go back to our normal method. You see the subject property is bound in red here on the map. As I was talking about, it had double frontage lots. There are 2 tenants that occupy this property. The portion that gentleman from Jocelyn's talking about is this auto repair business on the Murfreesboro Pike frontage. This frontage, I believe, is a dance studio. It has its access out on Old Murfreesboro Pike. The issue before this board, and I'm sorry this is upside down, but I was trying to orient it with the map. The existing sign, which you'll see in the following photographs, based on that sign's height and the request to replace that with an LED sign, they are required to be 350 feet approximately from a residential zoning district. That residential zoning district, as you'll see here, the closest residential zoning would be this mark right here where my cursor is at this point right here. This polygon which you see here is all R20 zoning. So that's the closest residential zoning district.
Looks like houses are over in this green area too. Are those houses?
Yes, there are. These parcels right in here are all still single-family uses. This is an R20 house. This lot here, I believe, is also a residence. It's not uncommon to see office or commercial zones still have remaining residential uses.
You were just saying that's the closest.
Yes, it's not. It is not measured from the residence itself, but from the zoning district that you see there. Yeah, it talks about shall be from residentially zoned property. This is looking at the subject site, looking up toward the business. The sign is just off to the left. You'll see it here. There is a billboard on this property as well. Really not germane to this. These are views of the adjoining property across Murfreesboro Pike. And then this is the sign that's at issue, and the request came to us to replace the reader board portion, which you see right here, with an LED. And is it right, Mr. Adcox, we're just talking about this face or the other face?
Well, we're talking about the face that you're seeing.
This face here.
That's facing Laverne, that face.
Okay. This other face on the back side, there's, I believe, a reader board on that side too that faces toward town.
That's correct.
You're still proposing to leave that as it is?
Pardon?
Are you proposing to replace that face as well?
No, just the one
Just
that you
this
see
one
in
that you see in the photograph.
picture.
So that's what came for you here, is they'd like to take that face off and replace it with an LED board. So that's the variance portion, is the distance from residential. Based on that sign's location and that R20 zoning, it's approximately 206 feet. So they need a variance of 144 feet. You do have letters in the record. Councilman Matthews came by earlier. You've got the letter from Councilmember Johnson in opposition. I also received one handwritten letter in opposition. Appears to be from Mr. Boyd Sanders. Here, I've got that if you'd like to. I believe you've been provided copies with it as well. Mr. Adcox, if you'd like to see that letter, I'll be happy to provide it to you to look at. That's case record as we have it. We'll turn it over now to the appellant. There is no opposition present. Last call? None? Okay. You'll have 10 minutes to present your variance case. All right, Mr. Adcox, we're dealing now with the variance. That's that later. If you want to explain to the board your hardships for the variance of separation.
What was the distance you got from that?
I've got 206 from residential.
And what's the height on 206?
I wish I had my little calculator with me that we use for that. If you'll give me just a moment, let's see. I've got 12 feet, Mr. Adcox. 12 feet, yes.
That sign from, by code, from grade to the bottom of that sign, if it's 10 feet off the right-of-way, it has to be 10 foot high. This sign sits further back. The top of that sign, the reader board sign, is actually 14 feet. By code, it says we have to be 12. We're asking to replace the face in that sign with an electronic as opposed to static. We can get a permit and put it up there and lower it 2 feet because it is CS, electronic is allowed, and that would be the height requirement to the closest zone residential property. We're just asking to replace the face.
I know Joey's tied up, but
I mean, that's it in a nutshell. I'm not a lawyer. I don't argue. It is what it is. Personally, how I see it, when this got passed, you've got highways in Nashville that are main corridors. They got 5 and 6 lanes. And because the way Nashville was settled, as every other community around, you got a CS property on the main street. It's 210-foot deep lot, and right behind it's a house, all up and down Nolans Road and everywhere else. And businesses are being restricted because somebody slipped a sliding scale in to the Planning Commission, and you have all these commercial corridors, secondary roads and things like that. I'm opposed to it. But here's a business that has a sign. He's out on a commercial highway. All he wants to do is change out and gather in new technology. Y'all do it. He wants to do it too. So and we can get a permit. We just want to use what's there.
Yeah, and I appreciate that, but also, if it wasn't a big deal, we wouldn't have, the council person and neighbors saying it's a big deal, don't let them do it.
It's a big deal, don't let me do it, but I can do it anyway at 12 feet.
Well, and I think that just speaks to the importance to those folks of the sliding scale, because at 12 feet, they'd say it's going to be less intrusive, and I'm sure that the folks that did it were thinking about, height and sight lines from, different lengths of space to residences, so it is less, bothersome to the residents if it's, whatever that height. So I understand what you're saying, but also, there are a lot of folks that have expressed that this should probably follow the rules, and
Well,
I guess I'm wanting to understand what the hardship is that would allow this one not to.
well, I have a question I think that relates to that. So, I don't know what the numbers are, but I'm sure you're, on all the other signs, you're allowed so many square feet of signage, face, and et cetera, et cetera. So if you didn't apply for this variance and you would put the sign at 12 foot, what would you do with the sign on the other side? The other face of the sign, would you move the whole thing? Would you leave one up and one down?
Not necessarily, and if I go back to the 12 feet height requirement, then I can put a lot larger message board up there
Yeah, guys, let me, I gave you some bad.
than what we're asking for here.
Right, that's what I want to try to understand. I know it's more than just a linear thing. There's a...
My high school math teacher would probably be yelling at me now. Where's she still living? So let me give you the correct height. Wait, here's what the code says. For signs 4 feet or less shall be 100 feet from any residential agricultural property. For each additional foot in height or portion thereof, an additional 4 feet shall be set back above 4 feet tall, shall be set back an additional 25 feet. So at a 4 foot tall sign has to be 100 feet. To me, 206, I've got 4 different 25 foot increments in there. So the height of it could be 8 feet and comply with the code. And that's measured to the top of that LED sign at 8 feet. So based on a 206 foot, I've got subtract 100 for the first 4 feet, take off 25 feet for each additional foot. That leaves me with 8 feet is how tall that sign could be and conform. Not 12, as I said earlier. So I apologize for that.
Okay, but the size of the sign, I'm sorry, I didn't follow that.
There are no issues with the square footage size of this proposed face. The square footage is fine. They're well under what they're entitled to in CS zoning.
I understand, but what if they're lower at the appropriate height requirement, do they have larger surface area of the sign at that point?
Yes, the surface area is not a function of the spacing. There's no correlation between how far from residential and how big I can be.
Okay.
If that helps you.
So if we were to give him relief on the height, in essence, he can make a bigger sign than what's there legally.
Not as a face replacement. As a face replacement under code, you're going back with something that's the same size or less in size, not greater.
So, okay.
I know you're not a lawyer, and I hear that, and you're making a very, very commonsensical argument, and I actually respect commonsensical arguments. 14 feet down to 8 feet, kind of, what's the difference? I mean, that's a very commonsensical argument, and I appreciate it. But we're only empowered to give variances if there's a hardship based upon the land, and I don't know what that is. So I'd love to give you the opportunity to tell me what about this land, is it narrow or undulating or something that is a possible variance? And I know I'm putting you on the spot.
No, I don't mind. I told you going in, there's no hardship. I've been out there. The property sets up off the level of the road. I forget how many feet. Didn't estimate it. So to go up higher is not beneficial. Coming down lower is beneficial because you come down closer to the traffic. So my client can go out there and not ask for a face replacement, which restricts him to the 3x6 or whatever the size reader board it is. He can lower the sign, and whatever the allowable square footage is for his parcel of property at that location, less what's on that top sign, he can put an electronic message center up there and get a permit, and it doesn't matter how many people object under the code. and you're not involved. In this
Sounds like a
case
heck
here,
of a plan.
it is a plan. He doesn't want to do that. All he wants to do, like a lot of people do, is he wants to be able to do a face replacement from a static reader board to some other means of communication. Now, if we were talking about a message board that scrolled, I wouldn't be in here because it only specifically says in the code electronic, and that's coming. The scrollers are coming. Nashville doesn't have any jurisdiction over them. It just says LED, and that's coming. We've gotten by codes in other places, and it's maybe not a good thing to say, by not going with electronic and going with scrolling because it was nowhere in their code. If it wasn't in their code, they couldn't deny it. They didn't even know what it was. This is simply, and I'm a practical, logical person. The man has a reader board up there. He just wants to swap it out. You're bound by some law, somebody telling you how to do it, and I'm saying there's no hardship. Do what you got to do. I'm going to go back and tell him you either passed it or you turned him down. And he and I both are going to sleep good tonight, and we're going to live with it. You know,
You're my kind of guy.
I'll be 68 years old next month. I pick my fights. This is not one of them. And I don't envy your position because I listened to the lady that came up here and talked about how hard she's worked all her life. Has nothing to do with the fact that it's not allowed. And I think this lady here did an excellent job of explaining it. She did on this case, and I totally agree. But here again, he has a sign. He just wants to change the face out in it. Now, personally, whether it's your rules or their rules, I think they're ridiculous. Because I hear electronic message centers screaming. Drive down the interstate and you'll see what the state has to say about it. Keep your eyes on your road and your head out of your apps. That's where the problems are. It's not with these electronic message boards. So I'm through. I'm not giving up. I don't quit. I presented my case. You have your rules. I have my thoughts. They have theirs. And it's either yes or no, and it's that simple.
Well, I admire the way you presented it, and I'm going to take this opportunity to close the public hearing.
It's a shame you couldn't make the motion.
Pardon?
It's a shame you couldn't make the motion there, so thank you.
Okay, discussion.
He doesn't have a hardship. He admittedly does not have a hardship. I do not see that we can grant the variance.
Yeah, as much as we may or may not disagree with what he said and appreciate how you said it, I really do.
You got the truth.
And I appreciate that. I really do, and I think everybody does. But I don't see an avenue for us to pass this.
Okay, I agree, but I like the common sense approach. I really do. Okay, so I'm going to make a motion that we deny their motion for variance, or their request for variance. Second. I've got a motion, got a second. All in favor? Aye. Passes.
I can leave now, right?
Yes, sir, before you go.
Thank you for your time.
Thank you.
Good to see you.
The next case on our agenda, case 2014, actually last case on our agenda, case 2014-108, Rigid Development is the appellant, and they're present. If you'll come forward. LVH LLC, owner of the property at 2120 Sunset Place, requesting a variance in the street setback in RS 7.5 to construct a new 3,597 square foot, two-story single-family residence with porches and or decks referred to the board under section 1712.030. The appellant has alleged the board would have jurisdiction under section 1740.180. Item B, opposition is present as well. Guys, you've seen how we've done this. You're free. I've got 3 seats, and when your time comes, you're free as many as want to come forward, please do, but you do have 15 minutes to present your side of the story. The appellant who sits before us also has 15 minutes. Of that 15, after you're done, you can save some of that for a rebuttal of the opposition's testimony. The opposition does not get a rebuttal of the rebuttal. There's only one rebuttal period, and it's to the appellant. Let me go over the case record as our office has it, and I'll turn it over to the appellant to begin. This case comes before you on a street setback variance. The subject property is located on the north margin of Sunset Place, just west of 21st Avenue South and south of Ashwood Avenue. This is the subject property as it appeared in February of this year. That residence has been demolished. And I believe there are, let me switch over to the site plan. The two exhibits that you see here submitted by the appellant shows the requested variance. The applicant is requesting a variance from the required setback of 47.5 feet and is requesting a 41-foot setback. And I'm going to skip. This shows the house location without a variance if not granted, and I'll come back to that during the appellant during his portion. But members, it's important I explain setbacks. The Metro Council has recently amended the setback requirements in R and RS districts by Council Bill 2014-770, adopted by the council going on, I think, 3 months ago. It used to be our setbacks were determined by the average of the two homes to either side of the lot. So we'd look at just those two homes, divide by 2, that's your setback. We'd also look at the plat, see if there's any conflicts. The council recently changed the setbacks now as the average of the 4 closest residences to the subject lot. So what we require applicants to do now is to obtain a survey, go and get the setbacks for those 4 closest residences, and it could be, it's not 2 on one side or 2 on another, it really is the 4 closest. So whatever that distance is. Based upon that average is how we determine the setback in this case. So I wanted to brief you on that. That is a recent change to the zoning code. So with that average, we determined that the required setback is 47.5 feet based upon that average of the 4 closest residences. This is looking at this subject property upon my visit to the site. And then views in the upper left-hand photograph are the homes to the west, here, and there, and the 3 homes on the east side of the property. And then another view minus the portage-on of the homes to the left-hand side. But again, the average of this property would be the gray and white homes, which you see here, these 2, plus these 2 here, divided by 4. That's the setback now for that case. So we determined that to be 47.5 feet. The applicant's requesting 41 feet. And with that, we do have letters. I'm looking for my note. We'd received 23 letters in opposition, 1 in favor, and 1 in opposition from Council Lady Berkeley Allen. So with that, I'll turn it over to the appellants and identify yourself and make your presentation to the board.
Okay. My name is Brian Layton with Rigid Development. Thank you, board, for your time today and your service to the city of Nashville. We appreciate it very much. Add to what Joey said about the change in the setback rules this summer. We actually were involved at some level in the discussions that led to that change, and we do support that change. I think it's important to add the intent behind that change, and I'll just read a part of the substitute ordinance. It says the contextual overlay district provides appropriate design standards for residential areas necessary to maintain and reinforce an established form or character of residential development in a particular area. So the reason for our variance is to uphold that exact intent behind the setback change this summer. If you see the 2 exhibits, based on required setbacks now, we would be behind all of the houses on either side of the new house. We actually built the houses on either side. Just a little more information. We at some level developed the street, and our intent over the last 2 years was so that the houses lined up as you come down the street. The street curves, and so if you see on the far right, the setback is actually 61.1 feet, but we pushed the house back that far to maintain the integrity and the character of that street so that those homes lined up with each other, so that that house on the far right was not pulled forward too far, which it would have been able to based on the old setback rules. We wanted to maintain that integrity, which is exactly what we believe the new setback rules are in place to uphold that. And so really all we're asking is to have a variance to pull that house forward to maintain the character and the rhythm of the street. I know that there's a lot of opposition from neighbors. We've read the emails, and maybe they all truly understand the intent of the setback rules and why we're asking for this. I don't know if that's true or not, but we did have a conversation with one of the neighbors that lives 2 houses to the left, and he was in opposition, sent in an email opposing. We discussed it. He went out on site. He understood it, and I believe he sent an email that changed his position, that he's now in favor of what we're asking. I think that, as I said, I mean, we do agree with the setback rules. We just think that this is a case that we're being forced to push this house back that kind of goes against the whole intent behind the setback rules.
So what's the hardship? Why do you need to pull the house forward?
Well, there's also a tree towards the back left of the property, and obviously the tree's back there pretty far, but my experience with trees is the further you get into the root system, as you dig footers and construction, then run the risk of that tree coming down. And, obviously our intent would be to save that tree if possible. But the further back that the house goes, then we're going to probably get into the root system of that tree. And the house that's designed on the site plan that you see, it's actually, we have a customer that brought that plan to us. It's not our plan. It's something that we're building for him. So that's what's being placed on the lot, not something that we designed.
On this photo that's up right now, I read some correspondence. Are these orange stakes where you're proposing the front of this build would be?
Based on the variance?
Yes.
Yes, ma'am.
Okay.
That's 41 feet back from the front of the property.
If granted, that's where the front of the house would be?
Correct.
So we're talking 6 feet plus or minus?
Yeah, 6.5 feet.
And it's really just the, as you're looking at the house, like this photograph, the left half of the facade. I mean, it looks to me that it's not even the entire front of the house that's in that setback.
Correct. About halfway across the front of the house, it steps back. And then also the street curves, so therefore, the further right you go on the house, the further back you are from the front of the property. But I think setbacks are based on the closest point of the property to the closest point of the house. So that's where that comes from. That's why we're measuring off that front left corner. So,
according to your argument, that the tree's the hardship. If you don't get the variance, you'd have to whack off 6.5 feet off of that little back portion of the plan. That's, I don't know what it is, the 8 3/4 by 15 foot on your surveyor site plan. Is that correct?
You say in order to keep the back of the house in the same location if it got moved back 6.5 feet?
If you can't build where that tree, or the distance shown from the tree on your proposed plan suggests that that's enough distance from the tree that you're comfortable with, that if you did have to move the house back 6.5 feet, you would have to whack off 6.5 feet of the house. Is that correct?
Correct.
Okay.
Any other questions before we hear from the opposition? Okay, so you'll have 12 minutes and 16 seconds of rebuttal.
Okay. Thank you.
Okay, as the applicant steps away from the table, those parties who wish to speak, and if any of the other folks, if you guys wish to speak as well, please feel free to move on up to the front row, and you can rotate out as these folks step away. Again, as we talked about for this opposition portion, you guys as a group have 15 minutes to present your testimony to the board. Again, it will stop for any questions and answers there too, should the board have questions of you. And with that, I'll turn it over to you guys. If you'll introduce yourselves. On the table in front of you will be the right button will activate your mics for you.
Good afternoon. Thanks for your time. I want to thank my neighbors for taking time out of their day to be here too. My name is Hunter Moore. I'm a 30-year resident of Hillsborough West End neighborhood. I'm the vice president of the neighborhood board, and I'm here to speak for the board. The board has voted unanimously to oppose this variance. Our neighborhood is a historic neighborhood. It's on the National Register of Historic Places. So preserving the character of our neighborhood has been very important to us. We gave input on the rewriting of the subdivision regulations that are, I guess, causing this request. We also worked very hard to expand our conservation zoning overlay this year to include most of Sunset Place. It does not include this property, but it comes within several lots of it. And outside of the conservation zoning overlay, our only protection is to enforce the existing zoning, including the setbacks. And our position that we've adopted is to support the existing zoning unless we're convinced that a change would benefit the neighborhood overall, and we're not convinced of that here. I also I feel like I have to acknowledge that there's some ill will toward this builder on the part of some of the neighbors having to do with other properties and circumstances, some of them adjacent to this property or close to it, and to the point that not everyone in the neighborhood trusts this builder to do what he says he'll do. And I'm just saying that in terms of it coloring some of the things you've heard through these emails and that you'll hear more about today. But that's all I really have to say. Thank you.
Hi, I'm Wendy McCooey. I live in the corner house there where the 61.1 is in the corner.
Excuse me, could you spell your name for our reporter, please?
Wendy, Wendy, last name McCooey, MCCOOEY.
Thank you.
Some of the ill will and the not trusting, I'm part of that. Rigid overbuilt my property, 2.5 to 3 feet, depending on where you're standing on the left, which caused my entire driveway to be dug up and repoured. I found out 2 months after we purchased the home, only because I harassed the builder to find out what was going on, because during the construction, there was some fence damage that raised some concern. On the right side of my home, I found out on a land survey that I had done that it's also a foot over, which interferes with an outdoor kitchen that's built. That's still not resolved. My neighbor has recently said no to an easement that I asked for, so I'm really not sure how that's going to play out. But as for the variance and the rules and the lot that we're discussing, they're in an email that Brian sent out last night to some people. I was one of them, in regards to their primary concern being that tree. If you'll look at 2116, the home next to mine, and if you're looking at the one to the right there, lot number 2, they have a 60-foot hackberry in their front yard, which is very close. I saw a picture earlier that popped up, which showed a really good shot. That home is very close to that tree. They butchered that tree. I mean, it was unbelievable to watch the way they cut the top and the root system to put in sewer lines and stuff. And that home that we're discussing, lot 2120, they're asking for the variance is way in the back of the lot. So I don't see that being a real hardship. One thing I did notice that was kind of a red flag to me was the distance in the garage to the right with the variance and without the variance differed. And that was kind of a red flag to me because of me not necessarily trusting the builder anymore. it made me think they wanted the variance just for financial gain, and so they could put the garage where they wanted it to be. Another concern of mine, I went over and measured those orange stakes. And if you're looking at the lot from the street, their first orange stake is approximately, I measured by myself, so this is not to the inch, but approximately 42 feet from the beginning of the grass line. And the middle one is somewhere in the neighborhood of 47, and the one to the right is 49 feet. My question is, they're asking for 41. Is that from one particular corner only? And then like the middle would stay at 47 and the middle would stay at 49. I'm somewhat okay with that because we're talking, you know, it somewhat lines up with the street or whatever. But if we're going to give them permission for 41 across that lot, left to right, then that gives them the approval to, in the end, because construction plans change, which I've learned because the home next to me is a monster and it wasn't supposed to be. It changed during the construction process. If we give them 41 feet across the lot, left to right, that allows them to bring the entire lot up 41 feet, which would make the right corner of that home line up with that huge hackberry next to the home on the right, lot number 2.
Joey, can we correct or clarify that question? Because I think that's an important question that you asked. But and as I understand it, it's from the property line to the closest point of the street.
It is for the measurement of the setback. And one thing this board has done is if you were to grant this, you can adopt that plan that you see before you. It's that plan, and not saying, hey, I can then
does that make
the whole
sense?
house to 41 feet.
And it's, I may be getting a commentary, but as I understand it, part of the issue here is that we're on a curve, and the curve, the curve is what makes it a little screwy. I mean, so if you're on a flat street and you take all the averages, and it's a straight line, and it's pretty obvious, but because it's a curve, you're further off.
Yeah, it gets tricky.
On one side you 49 feet, one side you 41 feet because of the curve, but it's the 41 feet from the closest spot is how it's measured. It's not 41 feet and then
so where those orange stakes are today is where the foundation would begin, correct?
That's what the appellant testified to.
And they would not be allowed to change that during construction?
If the board were to make that a condition, absolutely.
Yeah, if we were to grant the variance and to condition it on this specific plan that's presented to us.
I still think so the street does curve a bit, and just as I'm also a realtor and a salesperson, home values very important to me, especially since I live two doors down. And with the home having the curve, I feel it should go back more and not line up, because just curb appeal and aesthetically pleasing, it shouldn't pop out or completely line up because it kind of cuts in too much. It would look better, and to use a rigid word from his email last night, the streetscape would look better if they don't, all the porches don't line up, because then we're, if you've ever seen the movie, it's a bit cookie cutter, or the Truman Show, if you will. In our neighborhood, the homes don't line up on every street. It has character and charm, and when you start lining every porch up, so when you walk out, you immediately, are met with your neighbor, and there's zero privacy. That's not what I want for my neighborhood. I know I'm a new neighbor, but I like the character that it has, and I'd hate to see it go. That's all.
Okay, and Chairman, members of the board, my name is Dr. Jonathan Holt, and I live at 2304 Sunset Place, a few houses down to the west of the subject property. Built in 2012, my house was the first of the new construction completed by Rigid Development. First, I'd like to say that actually, I'd like to mention that we love our house. Rigid did a fantastic job with it. They're impeccable craftsmanship. And we still are amazed by our house. That said, I respectfully request that the Board of Zoning Appeals turn down Rigid's Development's request for a street setback variance for this property. There is no reason why Rigid cannot build a house that complies with the current regulation in place. After completing my house, Rigid obtained 4 contiguous single-family homes to the east of mine, including the subject property. After a series of subdivisions, this has resulted in 7 new single-family lots. 6 of these lots have been built on and sold. The last remaining is the subject property. It is located in the middle with 2 Rigid-built houses to either side. During a community meeting held at Village Real Estate in the summer of 2013, Rigid had assured the community that the homes would fit into this natural architecture, the streetscape, and that they would respect the street setbacks, among other promises. Looking at the plats and examining the proposed construction details, at first blush you'd say, well, it looks like it lines up. It's 6 feet plus or minus, but as anyone knows, the devil is in the details. First, my house sits approximately 64 feet from the street, and at the time, being the first new construction on the block, we believed our house would be the ideal of maintaining this architectural character of the street. And we imagined being able to sit on our front porch and watch our kids play in the neighbor's yard, and we have actually a lot of young kids in the neighborhood, and we've actually one of the appeals to this location. But now, unfortunately, I look at a brick wall to my neighbor's house immediately to the east of mine, where I used to have a beautiful view of the street, our neighbors. Now there's a house directly to the east of mine where I cannot see down the street my kids playing in the neighbor's yard. Second, at 41 feet, the proposed street setback variance will be the closest of any of them. I actually would like to point out there's some irregularities to the plate that was submitted by Rigid Development. The house marked as lot number 3, if you go back to some of the other pictures, actually has a porch, a full-length porch, not unlike my own. And I worry that actually the new owners of that house will run into a similar situation where they're wanting to enjoy their porch and watch their kids play in the neighborhood, and they'll have a large house construction blocking their view of the rest of the neighborhood. So in summary, the company now wishes to build a house that requires a setback variance on the remaining lot after controlling the development on either side. Any hardship here is strictly self-imposed, and therefore a variance is not within the Board of Zoning Appeals' purview. Rigid Development had the opportunity to submit their plans in the fall of 2013, as now having owned all 7 lots, to actually submit for the review of the Zoning Commission and the Planning Commission to review their plans, to adjust for this. So the characteristics of the properties are certainly adequate for a property scaled and that fits into this neighborhood at present without the variance. And I think any of these hardships are self-imposed by the builder. As a parent, I have 2 parting comments that are apropos. If you give a mouse a cookie, he will ask for a glass of milk. And 2, Rigid built their bed. Now they need to lie in it. So therefore, I urge you to oppose this appeal, and thank you for your service to our city.
My name's Greg Asadorian. I live at 2113 Ashwood, so it's
Could you spell your last name?
It's Asadouran.
Thank you.
And a couple comments that I wanted to make is just about the distrust with Rigid. I live adjacent to Wendy, who spoke when her house was being developed. There was some property line disputes, again, with my property, unresolved. I was told that I need to take them to court to resolve it. I just don't trust in Rigid. I don't trust in the plan. And I feel like there's some hidden agenda that we're not seeing here today. That's all I wanted to say. Thank you.
Good afternoon. Can you hear me now? Okay. Good afternoon. My name is Martha Stinson. I live at 2606 Westwood Avenue, which is 2 streets over. I'm also a member of the Hillsborough West End Neighborhood Board. And I just have 3 quick points to conclude. And one is that it's unfortunate, but there is a considerable amount of loss of confidence in Rigid doing what they present. And you've heard from two to three neighbors that have an experience to substantiate that. Number two, I'd like to restate that Rigid controlled the development of that section of the street and is left with a lot that they now want a variance on so that they can maximize their ability to build. So that is, the lots next to this lot have been built on by Rigid and in control of Rigid. So I don't feel that this remaining lot is suffering a hardship due to anything other than their own making. And number three, to address the streetscape. The fact of the matter is that 2304 Sunset Place, which is 4 doors down, is set way back and does not try to line up with the promoted line that we're hearing about today at all. And so it actually sits back 60 some odd feet. So 4 doors down is the subject property that, if built according to today's regulations, would sit back 6 feet more than the 3 intervening houses. That to me does not really interrupt the rhythm of the street. When I look at the pictures and the drawings of the house with the variance and without the variance, there's really not a material difference. And the variability of that street back line has already been established by Rigid itself. So therefore, I would request that you oppose this appeal for a variance as to not rising to any sort of level of hardship, and certainly to no peculiarities of the conditions of the lot itself or the streetscape. Thank you.
Okay, unless there's anybody else in opposition.
I think just to clarify, if you go back a couple more slides. So my house, there is setback 64 feet, and it's that one right there, correct? And so at the time of the the community meeting that was held at Village Real Estate that was attended by our Honorable Councilwoman Berkeley Allen, was when they made assurances that we would actually maintain that streetscape where my house was the first house that was constructed at the time. The second point is actually if you notice this, a couple more slides ahead is the with the orange stakes in the yard. Actually, I went last night with my flashlight to actually look at this again, and I think at first blush, from the street, you say, oh, it just fit. It's just, it's a plus or minus a few feet, but it is actually quite a bit forward from the house number 3 to the west of it. Jets out pretty significantly, and that house does have a porch, not a stoop, and so you really lose. And I've come to realize I didn't grow up here, but my family goes back 8 generations, and there is such thing as Southern hospitality where you entertain on your porch, and so I think that's the style that actually I wanted to have actually with buying this house, which I no longer have, and so that Southern hospitality of sitting on and entertaining on my porch and watching my kids play down in the neighbor's yard is lost. And so I think this is again, just to summarize, a self-imposed hardship that I don't believe should be approved. Thank you.
Okay, rebuttal.
Thank you again. I think that there were a lot of things said that I will just not address because I don't really believe that they're relevant to what we're talking about. I think the facts are that there is a tree at the rear left that we would like to try and keep, and based on the plan that the customer that we are working with wants us to build, that may or may not be able to happen due to construction. And then, just going back to what I talked about as far as the setbacks and the intent of the change this summer, the opposition did talk about that we have maintained ownership of this property over the last 2 years. Well, that changed this summer. What we're required to do and what we were intending to do changed during the time that we owned all of this property. So yes, we
did own the property, but had we known about these setbacks, we may not have put that house at 61.1 feet off the property line, the one on the far right. Our intent, again, is to maintain the rhythm and the character of the street, and we feel like with the variance, that's what we'll be doing, just following the intent of the setback changes. Thank you.
Any further questions? Okay, move to close the public hearing and discussion.
I need to make a disclosure if I could. There were a few of the letters in opposition I had not seen. One of them is written by a client of mine. I do not think that will affect my decision here today, but I do want to disclose that in case anyone has an objection.
Okay, discussion? I'll start. What the heck? I actually have a hard time seeing the hardship on this one. I mean, the tree is in the deep corner, and it is a fairly big house, and so there seem to be ways to remedy the problem without taking down the tree.
Yeah, it's not uncommon for us to use trees as a hardship, and I think in a lot of cases they are, and it does appear that one was right on the property line, and I agree that I don't see that. And I also think that there are times when the curvature of the street, which I think does go to the topography of the land, could create a hardship, and yet we're talking 6 feet. And I think that I haven't heard enough compelling evidence that says it has to be there, and that 6 feet is going to dramatically alter. I mean, we've had cases where the averages were strange, and it was 20 feet, and that clearly would create a situation like the neighbor talked about, where you're looking at a brick wall. But this doesn't seem to be that. So I'm having a tough time with it too.
Especially when you've got the open courtyard where you can kind of reclaim feet. But
I concur with the lack of hardship as I see one myself.
Well, the garage appears to be the same distance from the tree in both schemes, so I don't know. I can't see how moving the house is beneficial, or not moving it is harmful.
okay, then I'm going to make a motion that we deny the request for a variance based on the lack of a hardship.
I'll second.
Got a motion, got a second. All in favor? Any opposed? Passes.
Motion is to deny the request on a vote of 5-0. With that, the Board of Zoning Appeals is adjourned.